about 15 minutes. So I'm going to make this very fast and then I'm going to leave about 5 minutes for questions and then we can talk more about it tomorrow. But let's start with who can qualify for this. So you must show, and I know it sounds weird, right? But you must be able to establish that you entered the United States without inspection. So this is only for spouses of citizens and possibly even children of citizens who enter the country without permission. The spouse still has to show that they did enter and continuously reside in the United States for the past 10 years on or before June 17, 2024. So you basically have to show that you've lived in the United States for 10 continuous years before June 17th, 2024. You have to, of course, show that you're legally married and then legally married to a US citizen. And keep in mind that this is discretionary. This is still going to be considered on a case by case basis. So they're still going to look at positive and negative factors. They're going to look at whether there's a significant public benefit or an urgent humanitarian need that should warrant approval of this application. So don't take it lightly. Don't think that you can just take a marriage certificate, take proof of your 10-year residence, and submit that, and you'll be fine. You still have to establish these positive reasons or positive factors as to why the officer should grant your parole in place. So there is, and that has been my experience with even the military parole in place, which is very similar. They've expanded the now parole in place. This program used to be just for immediate relatives of US citizen military members, but they've expanded it. So that means that, for example, we still have to submit a declaration establishing or a statement from the spouse and from the applicant for parole in place, establishing why they are deserving of this discretionary grant of parole in place. Now, um, let me go through. I'm going to go through uh, the register quickly and just give you a rundown on what was said in the Federal Register. Before I do that, importantly, here's what you need to do now. Get your uh, get your USCIS account up and running. If you never establish a USCIS account, do it now because they're only accepting it online. And we work regularly with our clients in through the online system. So we're very comfortable with moving forward and moving quickly with filing this. So the form is going to be there. And the filing fee is $580. So you will need to make sure that you submit have that filing fee ready and set to go. It's form I-131F that you're going to have to complete to be able to apply for the parole in place. And then, of course, upload the necessary evidence to go along with this form in the portal. All right, so let's go over what they're saying in the Federal Register. So the most important part, and the part that I think everybody has a question about, would be first of all, as I said before, that the parole in place is still discretionary. So they still want to see through the evidence that you've provided that there will be a significant public benefit to granting you this relief. And the significant public benefit would be, of course, promoting family unity and stability, strengthening the U.S. economy. So I'm listing some of the factors that they're going to take into consideration here. So strengthening the U.S. economy and economic position of families and U.S. communities. Uh, advancing diplomatic relations and key foreign policy objectives of the United States, uh, reducing strain on limited US government resources. So, for example, they brought up here that the I-601A has been one of the burdensome processes that they've had to be going through, and so this will relieve that burden on U.S. embassies and consulates around the world, as well as agencies here that have to process the I-601A waiver, because the alternative to the parole in place is the I-601A waiver. Um, and then, of course, the urgent humanitarian need. So that would be, of course, things in regards to conditions in the country, in regards to the hardships that would come about, or even crisis that would come about as a result of family separation. So those are examples of an urgent humanitarian need. All right. So, one more thing. Now, does it allow someone who is permanently barred to still apply for this? And they have not mentioned explicitly the permanent bar. What they have stated is that the parole in place, being granted the parole in place, does not guarantee that you will qualify for adjustment of status. So that means that and what I'm reading from this is that they're saying that you may be granted parole in place, but you may still have inadmissibilities that could prevent you from applying for adjustment of status still, which includes the permanent bar, for example. So and keep in mind that the permanent bar, it does add some complexity to your case, because remember, they're looking at the pros and the cons. So, here's just an example. If you were deported, then you re-enter the country without inspection, that usually means that's a big red flag for the permanent bar. So, say in addition to that, you have an arrest, you have a criminal record, you have a conviction, then that definitely adds to the negatives, right? The negatives, and would likely increase the possibility of a denial based on the negatives exceeding the positives. But say that you have a permanent bar, but there are mitigating circumstances that led up to you re-entering the country. Say that you had to make sure that you could enter the United States to be with your children or be with your family, or say it was related to some form of abuse or some form of trafficking or smuggling into the country, and that second entry is mitigated by your circumstances, by possibly victimization or a compelling need to be with your family, or a compelling need to escape a dangerous situation in your country to get back to the United States to be with your family. That may be something that they will consider then, to say, okay, you have the permanent bar, but it's mitigated by the circumstances that cause your re-entry into the country. Now, if they do use their discretion to still approve the parole in place, that is not going to allow you to, that's not going to forgive the permanent bar. That is something that you would have to have an option to overcome at the adjustment of status phase, which in most cases there is no waiver for that, unless, of course, 10 years, some years has passed since you are outside of the U.S. and you can apply for permission to reapply for reentry. But that's a whole other thing. So, what I'm getting from this is that the permanent bar, it is going to add some complexity to your case, and we would really have to work hard to help you to overcome the negatives, and convince the officer that you are deserving of favorable discretion to get this parole in place. It is possible, but keep in mind that it is definitely going to be a challenge and it adds to the complexity of your case. So, if you do qualify for other forms of relief, you can always talk to me. We can talk about that as well. There's always VAWA. So, VAWA also allows you to overcome the permanent bar. And when you can overcome that permanent bar, it is possible to move forward eventually with getting the green card, right, through VAWA. So it's possible, but it does mean that we have to definitely address that. This process is not to be you should not mistake it for a simplified process where all you have to do is give your marriage certificate and your birth certificate and your passport and proof of 10 years of residence and you're good. This does when I have done parole in place, we have had declarations from the spouse, from the immigrant. Then we have evidence of relationship, evidence of entry, or how the circumstances involving the entry into the United States. Then we have the identifying information. So it's very important to make sure that you understand the potential implications and that you get the legal advice you need to move forward. While this is a brand new program and we all as attorneys are working to get through the process with our clients, I am experienced with parole in place, which is very similar to this. If you notice, I have released videos in the past about what to expect, and this is pretty much what what I said is pretty much what is happening here. Um, so let's see. So removal. Another question I've had is if you are in removal proceedings, then the question is, can you still apply for this? Yes, absolutely. There, once again, the removal proceedings may add some complexity to your case, but they have explicitly stated here that if you have an order of removal or you are in removal of proceedings, you can still qualify for this parole in place. It just means that we might have to take an extra step, though, an additional step of informing or getting in touch with ICE to be able to resolve the removal proceeding side of it. But it is absolutely possible, and they've said this in the Federal Register. Now, let me tell you about the crime. So, people have asked what kind of criminal conduct does, uh, you know, disqualify an individual from applying for this. So they have listed certain types of criminal conduct, and it usually has to be serious, considered serious criminal conduct that would usually disqualify you from even applying for adjustment of status. So some of those I'm going to list by the list here. But they have had a big but at the same time, and that is they are still willing to consider, once again, what I call mitigating factors. What were the circumstances surrounding the arrest or the offense, the conviction? So they have here age of the conviction, the person that was convicted, the sentence or penalty that was imposed, evidence of rehabilitation that you're law abiding now, that was in the past, you're now changed, nature of the conviction, whether it was violent or non-violent, whether the conviction was an isolated offense, so meaning it was something that was a one-time thing, it never happened again, or it was a mistake of judgment that you never repeated. Um, Evidence of mental or physical condition that may have contributed to it. So it shows here that they're willing to consider what I call mitigating factors. That means facts that tend to soften what happened, that tend to give a valid explanation as to why this happened. And, then allows the officer to exercise more discretion in the direction of an approval here. Now, the crimes, offenses that they have listed here would be murder, of course, murder, torture, rape, sexual abuse, it offenses involving firearms, explosive materials, destructive devices, offenses relating to peonage, slavery, involuntary servitude, trafficking in persons, aggravated assaults. So there's a list of aggravated assaults that under the INA that you'd have to take into consideration. This is where it's very, very important to get a consultation to, because when they say aggravated assault, it doesn't literally mean assault. For example, tax being charged with tax evasion can be considered an aggravated assault or an aggravated offense. Also, if you are, or an aggravated felony. So, aggravated felony. Aggravated assault here, I guess, would fall under aggravated felony. But aggravated felony is also considered very serious. And there's a long list of aggravated felonies, which involves fraud and tax evasion. Offenses related to offenses against minors, domestic violence, stalking, child abuse, child neglect, child abandonment, and controlled substances offenses other than simple possession of 30 grams or less of marijuana. So these, keep in mind that this list is not exclusive. If you have a misdemeanor, as I said before, a misdemeanor could still fall under an aggravated offense or an offense that renders you inadmissible. So being convicted for a misdemeanor should still not be taken lightly. Get in touch with us. Let's talk about it. But even though there is an offense, these are very serious offenses. If you have an offense, any offense, always check to see how we can overcome any kind of presumptions of being disqualified for this parole in place, because they've said here that they are willing to still consider different factors in regards to the offense. But these that I listed here, as you can tell, are very serious crimes, and most majority of immigrants in this country do not commit these kinds of crimes, right? So let's talk. I know, unfortunately, I wanted to have time for questions, but I have to jump into another appointment. So we'll talk tomorrow. And what I'm going to do is tomorrow, I'm going to answer only questions, and you can bring your questions again tomorrow about parole in place or anything else you want to talk about. I do represent clients in New York. Thanks for the follow. So you can give me a call. Do you represent clients in ATL? Absolutely. I represent clients in all 50 states and around the globe. So no matter where you are, I can help you. All right. So thanks, everyone. So what about the new rule, August 28 T visa? So they did release new regulations for the T visa, and there are a number of different changes. I would say a majority of them are good changes. They're not anything negative that would negatively impact the immigrant. But, whether you have specific questions about the change, you can let me know. All right. Thanks so much, everyone. I will see you tomorrow. Please come with your questions and we can talk again. So, once again, thank you for your time. Get on it. Get your USCIS account started. Go to uscis.gov. Get in touch with us. Let's get started on your case. Because remember, this is not just about being married to a citizen and being able to establish continuous residence for 10 years. Yes, that's a big part of it, but it is discretionary. So you don't want to start this off on a bad foot. We're very good at making sure we meet all these requirements. So that's where we come in. We come in to help to establish the positive factors, and that the positive factors in your case overcome the negative factors so that you can get favorable decision by the immigration officer. All right. Thanks, everyone. Have a great day. I'll catch up with you